we are going to go to Massachusetts today to finish up all of the things that we didn't get to finish up last time. And we have a new order from the court regarding discovery. Sometimes, Your Honor, you have just made things so much more difficult in this case. And we have a quick, or at least I think it's quick, status conference that we have not covered yet. I have not seen it yet. And so we're going to do that. The judge has proposed a discovery order and then asked the lawyer for feedback. And so then all the lawyers gave feedback. So we're going to look at the judge's proposed order, the lawyer's response to that order, and then the order that he actually made. This is from July 10th, proposed discovery order. On July 1st, I invited counsel, nay, you instructed counsel. I invited counsel to come to an agreement to hold private personal information in confidence. He said more than that. He said, I want additional sanctions. On July 6, 2026, I stated that if no such agreement is filed before 4:30 p.m. on July 9th, I would issue further orders I deem appropriate. Prior to issuing any such order, I invite the parties to provide comments on the following draft language. So he's just asking everybody to reflect upon the draft language. Quote, deposition testimony taken in this matter in the form of video or audio recordings or written transcripts, including private personal medical information learned at any such deposition or through discovery, shall not be disseminated and shall only be used for purposes of this case or McCabe v. Reed. Each party is requested to provide written comments, parentheses, 1 page and no more, to the above, the court, on or before 3 p.m. Monday, July 13th. As to other pending actions, although the parties to any related matter are free to agree to such limitations, I will not enter an order in a matter not assigned to me. Because there is a panoply of litigation. This court is only assigned the defamation case, McCabe v. Reed et al., and the wrongful death case, O'Keefe v. Reed et al. So let's take a look at the attorney comment, because at this point, the judge is just making work for the lawyers that doesn't need to exist. Plaintiff's request for clarification on proposed discovery order paper number 157. Plaintiffs appreciate and support the court's interest in protecting the confidentiality of private, personal, and medical information obtained during discovery. In order to effectuate the court's intent to strike the appropriate balance between protecting the privacy rights of parties and witnesses on the one hand and not to impede on plaintiff's ability to fully develop and discover evidence on the other, plaintiff respectfully requests clarification as to the scope of the proposed order. The proposed order prohibits quote-unquote dissemination of the entirety of every deposition without exception. Plaintiffs are concerned about 3 potential implications. Number 1, plaintiffs intend to use Ms. Reed's deposition testimony and that of other witnesses in future depositions for the purpose of establishing credibility issues. Plaintiffs believe that the court's orders or the court order should not limit a party's ability to use deposition testimony while deposing other witnesses. Interesting. We would like to show other witnesses Karen Reed's deposition and then ask them questions about that. Not every potential witness in this case will be deposed, and plaintiffs similarly will need to ask witnesses about statements made by Ms. Reed and other witnesses in deposition. The court's order should not hamper plaintiffs' ability to investigate the veracity of Ms. Reed's sworn testimony outside of the deposition context. Your Honor, we need to be able to tell the other witnesses what she said so we can ask them if she's being truthful. Finally, the language could be construed to prohibit the filing of evidence in motions before this court. Plaintiffs seek clarification on how the court would like the parties to handle public filings, specifically whether the court requires the parties to file under seal all deposition transcripts and all medical information, including information about Ms. Reed's medical condition, central to the intoxication issue in this case, used in the prior criminal trials, argued by Ms. Reed's criminal defense team, and disclosed publicly in the media by Ms. Reed and or her criminal defense team. The rules of civil procedure and the rules of discovery take these all into account, but I understand where plaintiffs are coming from. So if we want to file motions using things we learned in deposition, can we not do that? If we want to ask a bartender about something, can we not do that? If we want to use these in any way other than in trial, can we not do that? They go on to say, plaintiffs respectfully request the aforementioned clarification of the proposed order to assist counsel in conducting discovery efficiently while remaining fully compliant with the court's order. I don't disagree with Diller on this. Fair clarification. So that's what the plaintiffs had to say. Let's see what defendant Reed's attorneys have to say. Defendant Karen Reed's response to proposed order. And then instead of putting it on page 1, they just took an entire page on the next page, double spaced. Defendant Reed respectfully responds to the court's July 10th order. I wish they would have said invitation. The court's July 10th order seeking feedback on proposed language restricting use of deposition testimony. Reed believes that the court's proposed language is overly and unnecessarily broad. Okay, here's the thing though. I know a lot of you don't want to find yourself agreeing with Diller, but do you see the difference in approach? Do you see that Diller was just like, in all deference to the court, and I understand that the court's very, very valid, very noble, very, very wise goal is to strike this balance. Diller came in with, Your Honor, you're so correct. You're so correct, but also, what about these 3 problems? Reed's team comes in like a wrecking ball and is just like, no. It seems that the court does well with, hey, I understand where you're coming from, but we would like more guidance on this. It does not seem that the just straightforward, in-your-face approach goes well with the court. Reed believes that the court's proposed language is overly and unnecessarily broad and would significantly prejudice her. In particular, the court's proposed language would limit the use of, quote, all deposition testimony taken in this matter to this case and the McCabe case. That means that such testimony could be used by all non-Reed parties, plaintiffs, in the 2 cases against her where they have the burden of proof, but not in the 2 cases in which Reed is a plaintiff and has the burden of proof. There's a difference, though, with that for me, is that the judge does not have control over the federal case where Reed is suing and over the case against MSP and Canton. But I would imagine if they asked the judge to be allowed to use those depositions in the other case, that he would say no. I completely understand the concern there. The court said they didn't want to overstep into cases that they are not a part of. But I think that the court's core concern is that this all ends up on the internet. I think that's what the court's worried about, without saying as much. Reed's attorneys go on to say that no rule restricts use of deposition testimony in this matter, and in fact, the standard evidentiary guidelines permit the use of prior deposition testimony in later proceedings as prior sworn statements. Right. It goes on to say, of course, the court has discretion to restrict use of specific confidential information where necessary. Not the entirety of the thing, but discrete specific information. They go on to say, but the court's proposed language would mean that any admissions or testimony obtained in this case could be contradicted in either of the other pending claims in which Reed asserts claims. There is no justification for such a restriction. Reed has repeatedly submitted uncontroverted evidence that there was no violation of the court's impoundment order, which is the stated reason for this proposed restriction. I don't disagree with them. However, regardless, Reed has proposed to the parties that all deposition testimony and all personal medical information be used only for the 4 cases pending regarding these events and not otherwise disseminated. That seems reasonable. Plaintiffs have not agreed to this restriction, but that doesn't make sense to me that plaintiffs don't agree. Because we just read what plaintiffs said, and plaintiffs said We don't want this to be so restricted that we can't use it in this case. And it seems that defense is saying, we agree this should be used in all 4 of these cases, but not disseminated outside the case. Plaintiffs have not agreed to this restriction, but Reed remains willing to accept this restriction. If the court were to order such a restriction, Reed also requests that the court state that any party accused of a violation of the court's order will be provided with notice of such accusation and the opportunity to be heard before any sanctions are imposed. In this case, the court does not see themselves, and this is the problem, is the court does not see this circumstance as Reed's attorneys being punished in any way. I disagree with the court on that. I agree with Reed's attorneys on that. Because Reed's attorneys have been forbidden from doing any further discovery as to former Trooper Michael Proctor. And who is the person that hurts at the end of the day the most? Reed. So with that, do you want to see what the court does? This order is based on my plenary authority to control, manage, and oversee the conduct of discovery. Excuse me, Your Honor. Could you do that, though? And the court cited Buster versus George W. Moore, Inc., stating, in general, discovery matters are committed to the sound discretion of the trial judge. And citing other case law, Cronin versus Strayer, saying, we remind judges that the scope and timing of discovery is within their discretion, and that the prevention of discovery abuse is significant justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. The case law that the court has chosen to cite indicates exactly what the court thinks. The court is citing case law that reminds the court to kind of take the reins and make sure that there are no abuses of discovery, and that they should not hesitate to exercise appropriate control over the discovery process. The court says this matter was specifically assigned to me on November 14th, 2025. In the 8 months since then, I have been presented with various motions to compel, motions for a protective order, and motions to quash. The court says such motions have raised issues as to confidentiality of medical records, confidentiality of personal and disciplinary records, and possible public dissemination. Even after we read everything that had been presented to the court is still doubling down with possible public dissemination and or posting to social media of deposition materials and other privacy-related issues. Many of the motions involve depositions of non-parties. I read the language of Rule 45B as to, quote, undue burden to include a non-party's right to privacy in certain matters. I don't disagree that using litigation to harass non-parties is not okay. Putting an undue burden on a non-party is not okay, but it's for the court to rein it in. On June 29th, 2026, having been advised of information that allowed for a reasonable inference of a violation of an order of impoundment issued by me, I issued an order, paper number 139. In my July 10th endorsement on a motion for reconsideration, paper number 156, I acknowledged subsequent information as to the time of the June 8th, 2026 post on X alone did not allay my concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. So when the goalpost got moved, the court was like, fine, move the goalpost. So this litigation is stuck in a loop with this judge that is reacting to things seen on social media that none of these parties can control. The judge says, I invited counsel to come to an agreement to hold private personal information in confidence, but have been informed that though the parties sought to agree on restrictions on dissemination, they have been unable to reach a unanimous mutual agreement. Prior to issuing the below order, I invited the parties to provide comments on proposed draft language, and I did receive and have considered certain comments. Oh, not all, just some comments. We've considered some comments. Based on the above, the following discovery order shall apply in this matter. Quote, depositions taken in this matter in the form of video or audio recordings or written transcripts, including private, personal, medical information learned at any such deposition or through discovery, quote, protected information, shall only be used for the purpose of this case or McCabe v. Reed. Does he intend to limit deposition testimony to deposition testimony, including private personal information or private personal medical information only? Is he using that to limit the deposition testimony? So he's not saying all deposition testimony. He's saying deposition testimony that includes personal private media information, or is he using it more as an and? What do you guys think? I think there's room to argue that the comma is intended to limit deposition testimony to only deposition testimony that includes private personal medical information. But I think there's room to argue that he's saying all deposition testimony, specifically deposition testimony that includes private information. So let's keep reading. The court goes on to say this order is not intended to restrict the standard evidentiary guidelines permitting the use of prior deposition testimony in other proceedings as prior sworn statements, the use of prior depositions in other depositions in these matters, or the investigation of the veracity of any sworn testimony. So he's then also trying to limit it, saying we're not limiting the rules, but then why do we need this at all? Parties shall adhere to trial court rule 8 relative to the inclusion of protected information in any filings, including any motions for relief. So follow the rules. Notice of any claim of violation of this discovery order will issue and an opportunity to be heard provided before the imposition of sanctions. And then the court is quoting Campana versus Board of Directors of Massachusetts, quote, affords a judge broad discretion to impose whatever sanctions are just in order to ensure the discovery process operates efficiently. Footnote 5. The temporary preclusion on taking discovery from a non-party set forth in paper number 139 is vacated. You put it in a motherfucking footnote? He vacated the discovery stay on Proctor in a footnote. The stay has been lifted. The order has been vacated. It's been removed. It means discovery may go forward. So the court did attempt to limit the use of deposition transcripts, but also said it's not limited beyond the rules. So, Emily, what was the point of all of this? Well, the court wanted to make known that they are still concerned about information being publicly disseminated, that they are very unfriendly to any information that may be publicly disseminated, that they are skeptical that that is happening, and that any rebuttal of, hey, that's not happening, the court doesn't seem to be super amenable to, because the court is still concerned. There doesn't seem to be anything that's going to allay the court's concerns. So the court entered this discovery order, and then in a footnote said, oh, and you can go ahead and continue your discovery from former trooper Michael Proctor. And after this order was filed, they all had a status conference. And a quick break to talk about our case brief sponsor, Incogni. You've heard me talk about Incogni on stream, here on Case Briefs and podcast and everywhere else, because so often we're looking at cases where personal data becomes a topic of conversation. At the end of May, people were using Meta's own chatbot function to gain password reset access to people's Instagram accounts. So every day it seems like it's something new where you can get locked out of accounts, have other people accessing your personal information, and you just need someone to monitor it all for you. And that's what Incogni's for. One of my favorite things about Incogni is that I can set it and forget it, not just for myself, but for my family members, because they go after the data brokers that are continuing to spread and sell your information all around the internet and start taking it down. You can see the progress of what's being requested to be taken down if you need to take more action to get something taken down. And they even have a custom removal feature, which means if you need a little bit more help with something specific, they've got your back. You're not just left hanging. So if you're ready to protect your privacy and start getting your information off the internet, Incogni is what I trust with my and my family's information, and I think it will work for you. Plus, if for any reason it doesn't, they have a 30-day money-back guarantee. So if you're thinking it's time to take back your personal data with Incogni, you're right. Now is the best time, because if you go to incogni.com/Emily and use code Emily, you'll get 60% off annual plans. Now, let's get back to the brief.
What do you have to report relative to discovery and depositions?
12 depositions have occurred, and there are depositions on the calendar every day for the duration of the discovery period.
12 depositions have been done. That's helpful.
Okay. Any issues having people appear?
Yes.
Your Honor.
There was supposed to be a deposition on the 14th and there was still a stay in place. So yeah, it was real hard to get everybody to appear because of the court's order.
For Ms. Reed, this is Attorney Rosenberg. We've obviously filed a number of motions, but I don't believe there are any that are either outstanding via 9A or before Your Honor that relate to anyone appearing for deposition.
Yeah, I don't think I have any outstanding motions to compel anyone at this point in time. I think I took care of all of them.
I think that's right.
Okay.
We have everybody subpoenaed, Your Honor, and I don't have reason to believe that they won't appear yet. But if I come across that and we need the court's intervention, we'll file that forthwith.
Okay. Attorney Rosenberg, how many depositions does Ms. Reed have scheduled in the next month?
So we've taken, I believe, 6 and a portion. And then we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9, all scheduled within the current discovery period.
Okay. Attorney Daly?
Morning, Your Honor. For Waterfall, we have 3 depositions scheduled. We've been attending all the depositions as they've occurred, and we haven't encountered any problems yet with attendance or otherwise.
Good morning, Your Honor. We have 4 depositions scheduled for late July and August, and I, too, have not had any issues yet. In fact, counsel for certain parties have already reached out and been cooperative.
Anything else anyone wants to bring up?
I just wanted guidance, Your Honor, on how the court wants us to address what we addressed at sidebar regarding the privileges.
I think the way, from what I read, it appeared that there was still some discussion going on. And it didn't appear to me that an end had been reached in those discussions. So if I am incorrect and an end has been met, then file a motion. And if an end has not been reached, then keep talking.
Will do, Your Honor.
All right. I just wanted, for purposes, we were just trying to accelerate given the short turnaround as it relates to the discovery.
We have no idea what they talked about at sidebar and what the court wants them to file. But the inefficiencies that are just continuing to swirl here is just frustrating to watch.
Turnaround as it relates to the discovery period, to the extent that there is going to be discovery that's being withheld that we are entitled to. I appreciate we'll have those dialogues, Your Honor, but then my understanding was we were teeing that issue up to try to have some guidance on it so that if there's going to be further disclosures that are necessary pursuant to that disagreement that we raised at sidebar, it would happen timely so that we could use that data for depositions.
This is where we're ending up with everybody wanting their depositions to be at the end. Because you already hear what Diller's starting to say. Hey, but if there's more information, we want that information for deposition. So if we don't have that information yet, we want the deposition to go later, but we're running up against this deadline. And so there's a push-pull of wanting to push the depositions to the kind of end to make sure that they have the things they want before the depositions. This is not just a Diller problem. This is why Reed's team was in arguing over what was going to happen with the documents getting turned over from Colin Albert, because they wanted the documents before they did the deposition. This is both sides trying to have all the information they need before the depositions.
Your Honor, if just very briefly, what we're talking about right now is the form of the privilege log. These are privileges that we made, objections we made in October of last year. So I'm happy to speak with Mr. Diller right now at the end of this conference and find out what exactly he thinks he needs and try to get it to him.
Really? Rosenberg's just like, what are we talking about?
Right now at the end of this conference and find out what exactly he thinks he needs and try to get it to him. That's what I...
All right. So if everyone's willing, whoever needs to is willing to keep talking, that's great. And as far as teeing it up, I didn't anticipate it in our discussion that I gave an indication that we needed to have it done by today. But I understand the time issues, and if it gets to a point where you think it rises to the level of an emergency, I don't really know how it could, but you have the rules that you can avail yourself of and get the matter before me.
August 6th at 9:45 a.m. is the next status conference. It doesn't mean there won't be other things that come up in this case, but the attorneys all indicated that they have numerous depositions scheduled, that they don't see any immediate issues with people attending their depositions. A number of you asked, Emily, but where do we stand on Colin Albert's deposition? Well, when we left that hearing and saw the court's orders, the court kept asking for more information from the lawyers. So that is kind of floating out there, waiting for more information for the lawyers to figure out how they are going to do that. That issue is resolved in that it's in progress, but it's not resolved as to when Colin Albert will be taking a deposition. The court did make orders about what documents needed to be turned over there. We also don't know when former Trooper Michael Proctor's next deposition will be going forward. I imagine that we won't know when that deposition will go forward. I imagine that the date will be kept quiet on that unless it comes up in filings, but it seems that that has been a contention. We heard from plaintiff's counsel Diller that the plaintiffs have taken 12 depositions. We heard from defense counsel Reed's attorney that they have taken 6.5 depositions because the Proctor deposition is incomplete. It is in progress. It is ongoing. And then we heard that the Waterfall and CF McCarthy's each have a few depositions that they are waiting to complete. The Waterfall with 3, CF McCarthy's with 4. So there are depositions that need to happen. But what happens when the discovery closes? And we heard the court ask about this in the status conference. Once discovery closes, then they are going to move to dispositive motions, like motions for summary judgment. I imagine that there will be quite thorough motions for summary judgment, especially as to CF McCarthy's and the Waterfall. That's an opportunity for them to have themselves removed from the case before it goes to trial. And I think from Reed's team, they will try to narrow down the counts or the claims being brought against Karen Reed. So the dispositive motions can dispose of an entire part of the case and narrow down the issues before trial. Those dispositive motions are things that can really change what a case looks like going to a jury. And that is going to be, I expect, quite thorough litigation. And those generally are quite extensive motions with lots of exhibits and quite substantial court hearings on them. But we're not there yet. It is much more thorough than the early on motions to dismiss or the early on like anti-SLAPP motions and things like that, because those all happen before discovery. These are things that are happening after discovery. And so before this ever gets to trial and after discovery closes, we will have all of those motions that we will be going through, because this is the litigation that never ends. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.